why the court gave two conflicting orders. One is to ask the PDP to submit a name. The other one is for INEC to conduct election. And so they are both conflicting. And so which one? Are you now saying INEC should pick and choose which one should do? And then secondly, I think if you look at our constitution, there is basically, the constitution did not envisage that a governor elected on the platform of a political party will midway defect or cross carpet from that political party to another political party. It was never envisaged. And I think the drafters of the constitution, wherever they are now, would be turning in their grave that this is how we have desecrated, our ground law. That said, also the constitution did not, because the constitution didn't envisage that a governor would, defect after being elected on the platform of a political party. So the constitution also didn't prescribe a punishment or what should happen when a governor, defects from having been elected on the platform of a political party, now defects to another political party. Because the issue of cross-carpeting is also, it's well known in parliamentary parlance. It's a normal parliamentary practice, both in parliamentary system of government and in presidential system of government. The issue of cross-carpeting had always been there. And so, the constitution, the drafters in their wisdom provided for that in section 68 and section 109 to cover that lacuna, that in the event that you decamp or you cross-carpet, you will lose your seats. Except you can show that your cross-carpeting is as a result of the division in your party and that led to an amalgamation or a synergy. But in the case of Abegunde and INEC, the Supreme Court interpreted what the division meant, because before then, what the political parties used to do, or what the politicians used to do, is to create or orchestrate a minor crisis in their party, and they use that as an opportunity to job ship. And so the Supreme Court interpreted a division to mean that the division must have a national outlook in the party, that the party is almost divided into two parts or three parts, as the case may be. And so that rested this issue of, oh look, I move because there's a division in my party. And then, but on the case of the governors, like I said, there is no express provision in our constitution or envisaged by the constitution that the governors will do that. So in the absence of that, what ordinarily should happen would be for the courts to expand the law to fill in that lacuna, especially given the issues that we have, the prevalence of these jumpologies that we have now, if you permit me to use that word, where governors elected on the platform of a political party will just jump to another political party. What courts usually do is to expand the law. We call it the policy judgment, to expand the law to fill that lacuna. Then the question, the debate will now be, it's a federal high court, a policy court, that will be able to expand the law to fill that lacuna. To all intents and purposes, I'm not too aware if the federal high court is a policy court. But we, like we say in law, the law is what the court says it is. So, but we all recognize the Supreme Court as a policy court that can expand the provisions of the law. Even in India, for example, the chapter 2 of the Constitution, chapter 2 of our Constitution, which is similar to chapter 4 of theirs, the justiciability or the fundamental objectives and directive principles of state policy. Justiciability of sin, what the court did was to expand that interpretation to say, no, you can't give a right that is not justiciable. And so, to all intents and purposes, those rights became justiciable. We have this consistently saying it in our courts. So, in this case, we await the outcome of the Supreme Court. But, in my opinion, is the fact that there is no provision in our law, apart from section 188, that spells out how a governor can be removed from office. And one of such, is not that the federal high court can remove him when he job ship. But also you can say what the court simply did was to stretch the law to cover, that mischief. But whether that will stand the test of time or not, to see how that pans out. But I think we actually need to stem that tide of defection. Even though the court consistently, in some bread, the court had said, look, mandate belonged to the party. In another bread, they had said, in Amechi's case, the court said the mandate belonged to the party. But I forgot the name of the case now, the court said no, by virtue of section 141 of the Electoral Act, amended after the Amechi's case, that the mandate actually belongs to the candidate who the party holds it in trust for the candidate. But in Yaya Bello's case, the court, the Supreme Court also heard that the mandate belongs to the party. So there's an argument back and forth, but it is not as easy as Justice Ekwo has made it seem, because by virtue of the amendment of the Electoral Act, Section 141, you cannot be declared a winner of an election if you did not participate in all of the process. So if you sack a sitting governor and now ask that the party produce another candidate, the question will now be, did that candidate participate in the election? Wouldn't that your pronouncement have been violating Section 141 of the Electoral Act? Against that backdrop also, the next question would be, can the candidate be validly said to have been nominated, having not passed through the process of nominating a candidate, which is primaries? Can you say this candidate was validly nominated to fill that space? Is the time for nominating candidates, the window for nominating candidates has closed also? So all of these are issues that should be resolved by this appellate court. But I think at the end of the day, what might happen would be, the appellate court interpreting it one way or the other, and then also maybe creating a window for say, okay, when this happens, let there be another election, or maybe the person that came second in the primaries conducted by the party should automatically, step in to take the mandate, or as the case may be. So, but until that is done, we will just be airing our thoughts one way or the other on what we think should be the way forward.
Perhaps don't you think that now that they are even doing this amendment, constitutional amendment, can the National Assembly also bring into foresight this issue of defection, so as to curtail it in the near future? Maybe they should do an amendment whereby where you defect to another party, there should be a punitive measure to that effect.
I quite agree with you. I think now should ordinarily be the time, and it's a welcome development that this has happened now, and that it should give the legislature a window of peeping into this lacuna created by the Constitution, and use this opportunity to quickly amend the Constitution to cover that gap, so that we don't have to consistently rely on the court to fill in this gap in matters like this, because our democracy is still developing, and so as the issues come, we should be able to at least cover the gap or cover the feed in areas where there are lacuna. Another area I also need to talk about quickly is the fact that I also read that via an ex parte order, a state high court in Ebonyi has asked the governor to remain in office. I think that is an abuse of the powers of a judge, strictly speaking. Even though I do not agree with the judgment of the Federal High Court, there are modalities for appealing a judgment. You appeal, you apply for stay of execution pending appeal. A situation where you now go fishing for judgment or rulings from another court, for me, shouldn't be so. A situation where what the judge in Ebonyi just showed is the same thing that the governor accused the Federal High Court judge of, forum shopping. Or you go to a court that is close to you, a court that whose judges is under your whips and caprices, and then you obtain an order. Or saying, so what if you file an application for stay, and then the courts of appeal, in one way or the other, refuse that application for stay and insist that you must vacate the office pending the hearing that determination of the matter, which I don't think the court will do anyway. So will you now hold on to that, your ex parte order, procured order, to insist that you are validly still the occupant of the office? I don't think, so let's respect the sanctity of judges' pronouncement, no matter how much we dislike them. Let's respect the sanctity and the procedure, and exhaust the procedure for ventilating are grievance. I also learned that they have appointed, they were nominated or they have hired about 19 senior advocates now. So all of these also, some of the questions we should be asking is, where is the fund coming from? Will the fund come from the governor's private pocket or from the state coffers? These are areas we do not look at. This is a job that one or two senior advocates can do, or even a lawyer who's not a senior advocate and pursue this appeal vigorously, and at the end of the day the court will decide one way or the other. You don't need to go intimidate judges with a whole team of 19 senior advocates, because you want to prove a point. Even the matter at the trial stage had both a senior advocate on both ends. So for me, I really don't think
maybe they are just acting on the usual saying that the court is for those who know the law or those who know the judge.
Yeah, I think also I would also want, that's what, when you do things like this, that is the pressure you give to the ordinary man on the street, that maybe you also need some senior advocate to go intimidate the judge. But I don't think this is the time that a judge, even at the court of appeal level, who can be intimidated by, no matter the retinue of senior advocate. If in the days of G.O.K. Ajayi and Chief Rotimi Williams, they couldn't intimidate judges at the court of appeal, is it now that you would hire 19 senior advocates to intimidate? So these are some of the salient issues that we also need to condemn, because we make a mockery of the system.
Yes. Okay. Wow.